There is an internal tribunal inside the IRS called the Independent Office of Appeals. No one voted to create it, and it has held binding legal authority over American taxpayers since 1927 without issuing a single published decision. No judge confirmed anyone who runs it. No legislative body defined its powers, and if it rules against you, there is no transcript. There never was. Most people believe they have two choices when the IRS comes after them: pay or fight it in federal tax court, a real Article III proceeding, public docket, published opinions. What almost no one knows is there is a third option sitting between those two. The Independent Office of Appeals operates inside the Treasury Department, staffed entirely by IRS employees. It holds private conferences. No recording, no public docket, no press. You sit across from someone whose paycheck comes from the same agency pursuing your case. You negotiate. If you reach a settlement, the terms are sealed. The number is never disclosed. The public never sees it. The precedent does not exist. It was created in 1927, not by Congress, not by statute, but by an internal reorganization memo inside the Bureau of Internal Revenue. After World War I, taxpayers were flooding the federal courts. Agency administrators created this body to resolve disputes before they became litigation. It worked. Cases disappeared from the dockets. The backlog shrank. What no one stopped to ask was what this body actually was: an adjudicatory function, a dispute resolution body with binding authority, sitting inside an enforcement agency, operating outside Article III of the Constitution. A quasi-judicial tribunal created not by constitutional design, but because a federal bureau needed somewhere to put its overflow cases. It has operated continuously for nearly 100 years. It was expanded in 1943. It was renamed the Independent Office of Appeals by the Taxpayer First Act in 2019, Public Law 11625. It has never once been authorized by a public vote. Congress noticed the problem. The 2019 law required the Chief of Appeals to report directly to the IRS Commissioner. It prohibited certain ex parte communications, private conversations between the examination team pursuing your case and the appeals officer reviewing it. The word Congress chose for the title of that law was taxpayer first. The word they put in the agency's new name was independent, but independent from the IRS commissioner. It is not. The commissioner still controls the budget, still defines the mission, still sets the policy inside which every appeals officer works. The structural relationship did not change. The word did. Here is what this means for an ordinary person. Say the IRS audits you and determines you owe $60,000 in back taxes and penalties. You believe they are wrong. Tax court litigation would cost more in attorney fees than you owe, so you request an appeals conference. An appeals officer trained by the IRS, evaluated by the IRS, employed by the IRS reviews your case. She applies a standard called hazards of litigation. That phrase appears nowhere in the Internal Revenue Code. It is an internal doctrine developed internally, defined internally, never submitted to public rulemaking under the Administrative Procedure Act. It means simply, how likely is the IRS to lose this in court? If she believes the agency might lose, she can offer you a settlement below the original figure. You accept. You sign a Form 870 AD. The dispute closes. That settlement number is not public. What she found is not public. Whether the same issue settled at a different figure for another taxpayer 2 months earlier, you will never know. There is no case law. There is no published reasoning. The entire resolution happened inside a building on Constitution Avenue and then ceased to exist on paper. Remember, no one voted for this. No one authorized this outcome structure by name. Congress cannot simply codify it into a formal court of record with full transparency requirements. The moment appeals become subject to a public docket and published decisions, it becomes vulnerable to the Administrative Procedure Act, to constitutional due process challenges, to Article III scrutiny. The IRS would lose the informal settlement mechanism it depends on to avoid losing cases in federal court. So the structure must remain unofficial enough to escape legal scrutiny and official enough to bind taxpayers. That is the lock. It exists precisely in the space between formal law and informal practice, which is exactly where oversight cannot reach. Every reform preserves that gap, or the tool stops working entirely. And here is the part that should actually worry you: it is completely legal. The IRS Office of Appeals is not an anomaly. The Securities and Exchange Commission has its own administrative law judges, internal to the agency, hearing cases about the agency's own enforcement actions. The Consumer Financial Protection Bureau resolves cases through internal processes before they reach public record. The Social Security Administration's Internal Appeals Council handles more cases annually than the entire federal district court system combined. The IRS model is the template, a quasi-judicial body inside an enforcement agency. Private proceedings, no published law, no accessible precedent. If the resolution of a legal dispute, a binding outcome about what you owe the federal government, can happen in a private room with no public record and no published reasoning, what else is being resolved that way? And how would you ever know it happened at all?